Matt Gilmour sitting in for Aaron Rand today on Montreal Now. Thank you for joining us. It is 2:21 CJDA time. The judge in the sexual assault trial of 5 ex-World Junior hockey players discharged the jury today. CTV's Kamil Karamali has been following the trial and joins me now. Kamil, thank you for this.
Not a problem.
So what can you tell us about what went on in the courtroom today?
Yeah, let's not forget this is the second time the Justice Maria Caroccia is discharging the jury. The first time happened April 24th due to a mistrial. This is in the trial of 5 former members of Canada's 2018 World Junior Hockey team. And today's dismissal of the jury happened after something that took place of note yesterday. The defense, that a juror complained yesterday that the defense lawyers were acting unprofessionally. So a note handed by a juror on Thursday read, quote, "Multiple jury members feel we are being judged and made fun of by lawyers Daniel Brown and Hillary Dudding. Every day when we enter the courtroom, they observe us, whisper to each other, and turn to each other and laugh as if they are discussing our appearance. This is unprofessional and unacceptable." The judge then said that day, yesterday, an inquiry should take place where each juror was then brought into court separately and questioned about whether they could move forward and decide the case impartially. Then today, Justice Caroccia said that she has determined that it is appropriate to discharge the jury. Now, when she said those words, she did not say why, but what I'm highlighting is what took place yesterday. So not assuming that the two are connected, but worth noting that that is what took place yesterday, that a juror put forward a note to the justice saying that multiple jury members feel we're being judged by the defense lawyers. So today, Justice Caroccia thanked the 14 jurors for investing 4 weeks into this trial and then discharged the jury. What we do know is now that the trial will proceed before a judge alone, meaning Justice Caroccia will determine the guilt or innocence of the accused men solely, and that responsibility rests upon her now in terms of the fate of the former Canadian junior hockey team players Michael McLeod, Alex Formanton, Dylan Dubé, and Carter Hart, as well as Cal Foote. All 5 of them have pleaded not guilty to sexual assault in connection with an encounter that took place in a London, Ontario hotel room in the early hours of June 19, 2018. McLeod has also pleaded not guilty to an additional charge of being a party to the offense of sexual assault. Now, as I mentioned off the top, this is the second jury dismissed in the Hockey Canada sex assault trial of these 5 former members of the World Junior Hockey team. On April 24th, there was a mistrial also tied to alleged improper conduct by one of the accused defense lawyers. So a familiar scene here is apparently taking place a second time, where there was a complaint put forward by at least one juror against the defense lawyers.
And
Seems
Kamil,
like it's happened again.
And Kamil, have we heard from those defense lawyers yet?
Yeah, they put out a statement, and it is quite long, so I'll just read just a small summary of it. They said, and once again, this is from defense lawyers Daniel Brown and Hillary Dudding, saying, quote, "Earlier today, Caroccia decided to dismiss the jury in a proceeding where our client, Alex Formanton," that's one of the accused former hockey player on Team Canada, is a defendant. This was a regrettable development for Mr. Formanton. He had very much wanted to be tried by a jury of his peers and has now lost that opportunity. We, his counsel, found ourselves involved in the unusual chain of events that led to this outcome. In short, a juror came to somehow believe that our courtroom demeanor was disrespectful of her. This was an unfortunate misinterpretation. No defense counsel would risk alienating a juror, and nothing could be further from the truth in this instance. While it is true that co-counsel will speak with one another from time to time during a trial, this is commonplace. The very idea of counsel making light of a juror is illogical and runs directly counter to our purpose and function.
Okay, so just denying basically outright the allegation.
Exactly.
Okay.
Saying that, look, we have, in short, to put some words in their mouth, that we have nothing to gain from speaking about the jurors in a, quote, inappropriate way.
Okay. Thank you for this, Kamil. Appreciate it.
You're welcome. Lots to still come.
Absolutely. Okay. We also have here with us to talk about this a little bit more is retired Judge Nicole Gibeault. Madame Gibeault, thank you so much for being here.
Thank you for having me.
So you just heard a little bit the summary from our reporter in London.
Yes.
What do you, from your perspective, for the judge, is it a big decision for the judge to make to dismiss the jury and take control over the trial?
Absolutely. It's a huge decision. And because there's many lawyers with a lot of accused in this case, and the judge needs to respect the Crown's position. She needs to respect the attorney for the defense, the accused position. And I like to remind you that it's a choice that the accused did make to have a case judged by a jury, and that was their right. Now, in order to get, because we heard your journalist saying that it was because of a situation that occurred, a jury thought or said, send a note to the judge, Carachia, and she said that she felt that she was looked at in some inappropriate way, and for that reason, what can the judge do? What can Judge Carachia do is to either make an inquest with all the jurors and then see if it's proper to discharge or not. But eventually, how would they absolutely be sure, everyone, that the jury did not speak together? And it's difficult to have an impartial jury and an ability to render an impartial verdict if something leaked. One looked at us this way and blah blah blah. They can't control the what was said or not. So in that case, yes, it's difficult, very difficult, but it's difficult for the Crown because the Crown at first was not. Did not agree to discharge the jury and not to have another trial by jury. They didn't want to go before judge alone, which is a perfect legal way to go through with that, only if every accused accepts.
So if I'm understanding you correctly, it sounds like perhaps this judge maybe felt like the jury was no longer able to be impartial, and so therefore in some ways dismissing the jury is to actually protect the defendant in many ways if the jury was feeling sort of animosity from the defense attorneys. Absolutely.
And I think that a good night's sleep sometimes helps, and it helped everyone, I think, in the circumstances, because we saw the Crown's attorney's position change. We saw also that all the defense attorneys, they needed all to accept in order to continue in front of a judge alone, which is the same position in law. Of course, the presumption of innocence and reasonable doubt and all those theories are exactly the same. It's going to be maybe a little bit quicker because it's in front of judge alone. Because, in front of a jury, sometimes we need to explain very, very carefully. It's very normal. They're not particularly. They don't know the law,
Sure.
and we have to. People have to be informed. The judges, alone, it's different. She will be able to assess the situation maybe quicker. But then again, it's a huge, huge decision for the defense attorney to have agreed to that, because they won't be able to say afterwards, well, they forced us. You can't be forced. You either accept to go with judge alone or you don't, and then that would have been complicated.
Okay,
but
so for her to have dismissed the jury, she needs to get agreement from the Crown and the defense.
Well, in order to get, not to dismiss necessarily, because she did accept the dismissal from the petition from the defense, but in order to continue with judge alone. That's the big decision, to continue only with a judge and not with a jury. All the defendants needed to accept that situation. And I think they all signed it and delivered it to the judge.
Okay. Madame Gibeault, retired judge, thank you so much for your insights. Really appreciate you taking the time to speak with us.
Thank you so much.
Okay. Bye-bye. It's 2:31. Your news is next.